Hello, welcome to another episode of the ARM podcast. I'm Abbas Kazerounian, your host, and we have a very special edition this month. We are introducing to you one of our newest team members, newest in fact, Judge Trevor Atkin, who will be, well, not just will be, is and will be available as a neutral, as a mediator, arbitrator, special master, and so on and so forth. Welcome to the team, Judge Atkin.
Thank you, Abbas. I really appreciate the opportunity to do this. It feels like a natural continuation of my career coming over from the court system.
Well, we're super excited to have you. And I don't think I've actually been overwhelmed by so much, outside input about a neutral coming on before. It's a random people have been texting me, emailing me saying, it's such a great addition to the panel. We're super excited to be able to use him as a neutral. And, I think we were taking calls and bookings for you before you were off the bench. So, kudos to you. And I can't wait to see how this, portion of your career flourishes. So anyway, without that, I really want to get into this because I want to talk about your immediate past, having been on the bench. And one of the questions that kind of seems to be going around in almost every legal field, and the Nevada legal field is no exception, is what is the state of the court system? And when is the earliest you think we're going to be able to get a jury trial, at least in the civil context? And someone that's literally just left the bench days ago, I think there's no one better positioned to answer that question than yourself. So if you could kind of give our viewers and listeners a bit of insight into that, that would be amazing.
Sure. I was asked that question all the time by my friends and colleagues, and the answer was always the same. I can't predict it. The chief judge is the one who decides that, and Chief Judge Bells has done and continues to do a great job. And her overriding concern is we can't put jurors in harm's way.
Right.
For the sake of jury trials. Jury trials are important, but they're not more important than keeping our jurors safe. So I always come back to whenever the medicine and the health district and the people that specialize in this say it's okay, that's when they're going to go forward. But believe me, the courts and the judges know how much pressure there is to open this pipeline, so to speak.
For sure. And I'm really happy to hear that safety is of the utmost importance. And I think that carries through in almost any field. But even in the ADR field, I know a lot of people have, are always calling saying, we really want to do an in-person mediation, but we're really concerned about the health and safety of the participants, which includes the neutrals as well, and the attorneys and the participants and and the litigants involved in the litigation. And I don't think that's any different with the court system. Because if we lose the jurists, even if you could do jury trials, who's going to preside? So
right.
His health is important.
Oh, I respect that absolutely. And I know 2-3 weeks before I left the bench, we tried a bench trial. It was a short one, and it was done in person. Everyone felt comfortable. The litigants, the attorneys, my staff, because I wouldn't put my staff in harm's way unless they felt comfortable. We did the social distancing. We had masks. We took every precaution because, my preference is I love to be in person. I think it's more effective. It's just natural.
Yeah.
But certainly my morning calendar was all done remotely, similar to this podcast. It's forced us to be nimble.
Yeah, it's kind of. I'm kind of going off tangent a little bit. How much of this do you think is gonna? I know in the ADR world, a lot of this is gonna stay in place. I think we're gonna get much more in person because, like you said, a lot of people like that in-person feel. I think you get a better connection. But in the court system, for status conferences, why wouldn't we carry on doing Blue Jeans or Zoom or whatever it may be?
That's what. At first, it was very awkward. But then it became, maybe this is a better way to do it. And it allows for more pro se litigants to appear without coming down. And it allows attorneys to hop on a call, they can be sitting on 3 or 4 calls for morning calendar and just pop in and out of each one. It's considerably more efficient.
Yeah, economic for the actual people paying the attorney's fees as well. They don't have to pay for for the travel, and I think there's a lot of positives that we can take from this horrific experience that we're going through as a community. My last question that is kind of related to the court system before we move on to your kind of immediate future is, let's hypothetically say that we're all okay now and the vaccine's there and that and everybody's going to be safe moving forward. There's already a massive backlog on the stacks in Nevada, on the trial stacks of what hasn't been tried. If you opened up that pipeline, let's say next Monday, my question is like, I mean, are you realistically, like, unless you're already in that pipeline of, your trial date is already being postponed and you're due to go into a trial because your litigation timeline is getting to that position now, are you realistically going to get a trial in 2021?
My thought is a civil trial, it's going to be tough because there's priority settings. First, there's the criminal dockets that need to be handled. But then you're going to have, if it's an all civil department, then okay, I presume they're going to continue their all civil. So you're going to get the firm trial settings that are in place, and those. Then you've got the med mal cases that are going to take precedent. And then, of course, you have the 5-year rule cases that are taking precedent. So, I would say 2022.
Yeah, it's going to be a hard push. So, interesting. Anyway, let's change gears a little bit and talk about even more exciting things, which is your immediate future. So you've joined us at ARM, and I think one of the questions that if I'm a viewer, a lawyer in the community, why ADR, Judge Atkin? Like, what is it that you feel that you're going to be able to accomplish with ADR, and why ADR? Discuss.
Sure. Because of the backlog that's been created, these cases are just languishing, and the only way, I always like to think, the only way, once a lawsuit gets started, the only way that the parties can control the outcome is through ADR. I volunteered umpteen times for settlement conferences as a judge, and I like it. And it creates some certainty to give the parties the chance to steer the case where they want it to go, because once it's just languishing on a stack, or then it gets in front of a jury, there's no control. So this is their last means of controlling the outcome. I always say lawsuits, I'm not the one who coined the phrase, they have a life of their own, but they truly do.
Right. Interesting. And what makes you passionate about ADR? What is it that makes you want to get into this field and be somebody that facilitates these resolutions?
Well, it allows me to have a hands-on approach with a case where when you're an attorney representing a client, you can only push against the wall so much, and then the other side's pushing against you. But once I was on the bench, I realized, the ball is in my court. I can manipulate and move the case, not just by the decisions I was making. I didn't have a specific goal in mind, but I would get a case, and I wasn't advocating one way or the other. I was just trying to do my part in moving the case along. So with ADR, it's okay, I've got this case in front of me. I can see the pros, the cons. I can see where it may best move to get in a position to be resolved. And then once I'm done with it, hopefully it settles, it moves on, and I take on the next case. I'm not steering a ship from start to finish. It's coming into my office kind of like a doctor's office. What can you do to fix this problem or to resolve this complaint I have, this problem we have?
Yeah, it's interesting how you can use your experiences as a jurist in the mediation process, for example, but you have a very different role, and but that experience is so useful in being able to facilitate your role as a mediator, which, as we just discussed, is a different role to being a jurist and a judge.
Oh, it is. But as a judge, I had to stop myself short, of saying, like you get it as a mediator, it's, hey, look, I can't predict the future, but I have a good idea which direction this ship is headed and what waters you may want to stay out of in candid conversations going back and forth between the rooms. I can tell them that and say, you might want to think about X, Y, Z, seriously.
Yeah, it's, as a litigator, like I always love reading judges, like, there's some that keep it really close to the chest and they're like, this case should be settling because if this goes to this dispositive motion, someone's going to get hurt. I'm not going to tell you who, but somebody.
I said that a time or two, but I learned that the sharp attorneys out there, they look for tells.
Yeah.
And I tried not to have a tell about, I know what to speak of.
It's true. So kind of like, there's a good transition about your experiences as a judge, but that's not the only experience you're going to be bringing into your role as a neutral. Like you had like an extensive experience as a trial lawyer. I mean, if I'm not wrong, I think you tried more than 30 odd jury trials to verdict.
At least.
And so I think, there's a lot of jurists that don't have any trial experience. And I think that kind of distinguishes you to other judges maybe. And, your experience as a litigator as well. Like, which part of these do you think you're going to most draw from to be able to be the most effective neutral?
You know what? I don't know if there's one more than the other, but I do, I used to have associates and then my law clerk, something would develop in a lawsuit and they would say, well, how did you know that was coming? It's like, dude, come on. I did this for 30 years. You do something enough times, you kind of figure out what is going to happen next. The odds are. But then when you get from the judicial side, you understand what's going on behind the scenes that may impact a case. So that adds to, okay, I know how to value a case. I know the pitfalls of a case. And I know it from a judicial perspective as well as a trial attorney. You put those two together, and I think I have a pretty good crystal ball I can bring in to each room as I'm going back and forth.
Let me ask you a question, kind of going on a slight tangent, just because I think it's such a, trials are such an amazing, and curious topic to discuss. And it goes so much hand in hand with kind of, leaning on parties to try and, help them and, twist the arm here or there to try and settle a case. I mean, I don't have 30 jury trials under my belt. I probably have 8 or 9. I've got maybe 40 bench trials. But with bench trials, if you can have a good guesstimate at how the evidence is going to shake out, and the law is the law and the judges tend to follow the law. So you know how that's going to work. In jury trials, I really have absolutely zero idea how they're going to deal with the evidence, like zero. I mean, there's certain things that I know are important, and you do focus groups or whatever. And, even members of a BOTA that I've talked to, which I know you're a member of a BOTA, they always tell me, you can never read a jury. But now that you've had the judicial perspective of juries, do you think you have a better read on juries, or is it still an anomaly?
I have a better read, but it's still an anomaly. I think some people just have an innate ability to judge the temperature of the room. Okay. I always considered myself, I was kind of getting a vibe during the course of a trial. Of course, you start when you're picking the jury, and there's certain demographics and things you're looking for to fit your case or your fact pattern. But then as the case goes on, it always morphs into something else. Rarely does it go just as planned. Like they say, all the battle plans go out the window as soon as the first shot is fired.
Yeah.
Some folks have a wooden ear. They just don't get it. And I always considered myself to be able to I can kind of see which way this is headed and adapt accordingly. As a judge sitting there watching it happen, I could focus more on the jury because there would be some, pretty boring points of the trial, and I could just kind of watch the jury even more and just tell kind of what was happening. But even then, there was a surprise or two.
Yeah.
Like, oh my God, they bought that. I didn't think they would.
Yeah,
that's what, I sat in on, God, hundreds of mediations where I was in one room, and it's always started with, I won a lot I shouldn't have, and I lost some I shouldn't have. And it still holds true. People are people, and you can't predict the outcome. The best we have is kind of a crystal ball.
Yeah, it's so true. They always say your best case, you're still gonna in a jury trial still lose it twice, like out of 10. So
yeah,
that's right. That's my experience.
And if you haven't ever been surprised, you haven't tried enough.
Yeah, for sure. That's for sure. I I don't have anywhere near the same kind of experience as you do in trials, but I mean, even within
older. I'm just older.
But still, like, literally every day something crazy happens, and even on your own witnesses going sideways on you.
Those are the worst.
Yeah. But kind of like final area, just what in your kind of new career as an ARM neutral, what kind of cases are you most excited about, most looking forward to being help resolve for people?
I would say it's personal injury litigation primarily, because it's what I did for 30 years. It was primarily from the defense perspective, but we had a couple good plaintiffs cases, and I spent 30 years on the phone and in meetings with insurance executives and adjusters, and then plaintiffs counsel, just, okay, what are the pros and cons of this case? And many times I had an adjuster who may have been undervaluing a case, and how do I diplomatically tell this person that's holding the money and who's paying me, how do I diplomatically tell them, you've got a blind spot here, or point something out diplomatically? Because remember, I needed repeat business, so I didn't want to step on toes. And I didn't want to look weak, but I needed to diplomatically let them know there may be troubled waters ahead.
Yeah.
And I think I can have those conversations in a diplomatic fashion to maybe put a new light or perspective on the case. That's what I look forward to the most.
Lovely. We're kind of coming to the end of it, but like just the kind of like, the final words on your new career at ARM. There's two real reasons why I'm particularly excited about you being a neutral at Advanced Resolution Management. The first, I think, is that you're kind of unique in a certain regard, that there are a lot of successful and talented mediators that were great litigators in their time. There are certain mediators and neutrals that were good, that did a lot of trials. And then there are a lot of good jurists that were phenomenal trial judges during their career as a judge, and then became mediators. But very few have that trifecta where they did all three. You had an immense career as a litigator. You tried an amazing amount of cases to jury verdicts, and you're an HON. So the different perspectives that you're going to be able to bring to the game of being an arbitrator and then specifically a mediator, I think is a unique thing, and I'm really excited for our clients to be able to utilize that talent. But most importantly for me, and what excites me, is what a nice guy you are, and the energy that you bring. You're obviously extremely accomplished, but you walk in a room and I'm like, I love that guy. I want to go get a beer with him, you're
making me blush.
Well, it's the truth. It's the truth. I wouldn't say anything otherwise. And I think people, litigators, lawyers, usually good, like being around good people with good energy. And I think when you walk in a room, your energy kind of lights it up a little bit. And I'm really excited for our clients to be able to kind of, see that and experience it if they didn't have the experience of being before you as a judge. And I'm sure if they had a taste of you as a judge or as a, opposing counsel or co-counsel, they want to probably taste it even more. So with that said, I really want to thank you for your time, Judge Atkin. And I am so proud to have you on board at ARM in the ARM family. And we really look forward to seeing more of you and having our clients come and utilize your talents.
Kind words, thank you. But at my investiture, they said similar kind things. And I said, you know what, that's really kind, but I have not yet earned it. I look forward to earning it. I had to earn my keep as an attorney. I had to earn my keep as a judge. And I really look forward to earning my keep as a neutral with all the great other people at ARM, because I want it to be said, hey, because I know how these phone calls work. Let's try to settle the case. Do you want to do private? Yes. Who do you want to use? Call ARM. There's plenty of good people over there, and that will get it handled through one of their experienced neutrals. And I want to be one of the contributors at ARM.
I have no doubt you will, and I really appreciate your kind words. Thank you again for your time. And with that said, looking forward to seeing everybody else on the next episode. Thank you, and welcome, Judge Atkin.
Take care. Bye-bye.